Well, they were certainly powerful images. Dean Del Mastro, a Canadian politician, once the parliamentary secretary to Prime Minister Stephen Harper, being led from court to prison after being convicted of election fraud. He was sentenced to 30 days in jail. That was in 2015. Today, Del Mastro was back on Parliament Hill complaining about the unequal treatment by the Commissioner of Canada Elections. He points to the compliance agreement offered to Quebec engineering firm SNC-lavalin in 2016 to escape criminal prosecution for making illegal donations to the Liberal and Conservative parties. What does Dean Del Mastro want? Let's find out. He's with me now. Dean Del Mastro, good to see you again. Thanks for coming to speak with me. You're making the case that you were unfairly treated based on the way SNC-lavalin was treated for violating election laws. What's the claim you're making?
Well, I think, first of all, I'm not saying necessarily, I'm saying to Parliament, let's take a look at this. If I was fairly treated, and that's the position of Elections Canada and the Commissioner of Canada Elections, and we have to look at the disparity and say, okay, if what occurred to me was fair, then why were others dealt with much differently for offenses that certainly on the face of them are much more significant?
Okay. The conviction, the charge you were convicted of was failing to report personal contributions of $21,000 to your own campaign. And in SNC-Lavalin's case, right, it's $120,000 to two political parties, largely the Liberals, some to the Conservatives. So they received an offer for a compliance agreement. And were you ever offered a compliance agreement? Did you ever ask for a compliance agreement?
Oh, sure, we asked. My immediate call when I first learned that there was an investigation going on, I was completely blindsided when there was a sealed court document that was leaked by the Commissioner's office. And I immediately called Elections Canada and I said, I want to meet with somebody. I need to discuss this. And I was told that they wouldn't meet with me right away, that they would get back to me the next day. And when they got back to me the next day, I was told that they weren't prepared to meet with me. And then when they did finally agree to meet with me, it was under a caution statement. So there was never any offer of a compliance agreement.
Okay, but there wasn't an offer, but did you at any point in this process ask for it?
Oh, constantly.
Say, look, can I, okay, all right. Yeah. So, but to receive an offer of compliance, or an offer for a compliance agreement, you have to admit guilt. And to this point, you've never admitted guilt, have you? You to this day maintain that you did nothing wrong, that this was an accounting problem, essentially. So how would you qualify for that compliance agreement offer if you weren't prepared to say, okay, I'm guilty, let's talk?
So I think what I've said and what I've always maintained is that this was an accounting dispute. And if the suggestion was made that we accounted for something incorrectly, we reported everything. Elections Canada received all of the report. They knew that I had made a contribution to it was reported into the riding association and some into the campaign. They always knew that. Everything was provided, all canceled checks, everything was provided. If their position was that they didn't agree with how we accounted for it, I would have had no problems entering into a compliance agreement saying, we accounted for it as such, it should have been this way. Fine. But Elections Canada has also maintained in other cases, including the Conservative Regional Media Buy, which was known as In and Out, that the way that we accounted for it is exactly the way it should have been accounted for.
Right. I mean, you're not here to retry the case necessarily, but you're here to believe what you set up are differences in the way you were treated by them versus SNC-Lavalin.
Disturbing differences.
Yes. So, okay. If you were prepared to, I mean, I guess a lot of people listening to this will say, look, you were charged with violating the Elections Act. This is what happened to you. And they'd look at SNC-Lavalin. A lot of people would say, look, we don't like the thought of compliance agreements at all. So Dean Del Mastro got what came his way, and SNC-Lavalin shouldn't have got one either. Is that germane to the conversation? Forget the compliance agreement. You got nailed. They got nailed. They should have all been taking the medicine.
Great. And I mean, if that was the conclusion of Parliament, I could accept that. What I can't accept is a Commissioner of Canada Elections that selectively prosecutes people he doesn't like. And on the face of it, that's exactly what's going on. We have a practice of selective prosecution, and we've seen that with SNC-Lavalin and other matters. And by the way, SNC isn't the only case. Today I raised the issue of MP Spengeman. He was accused of more egregious violations than I was. And after my case had been brought to court, and he got a compliance agreement, I just don't
So
understand
you say
what the
you believe you were
qualifiers are.
targeted.
Oh,
For what purpose?
Well, I just think that beginning in 2008, when I was defending the Conservative Party at committee on the regional media buy issue, and then again, I was.
That was a fight with Elections Canada.
Sure, it was.
A very public fight.
Very public fight. You know, I was assigned to go in and discredit anybody. I mean, we were on the eve of an election. And anybody that would say anything negative about the party, basically, my assignment was to discredit them. I wasn't even a member of that committee. Called by PMO, asked to participate, went in with instructions. It wasn't, you know, I didn't have a beef per se with Elections Canada. It was part of the job, right?
Right. And you think this was
I think
this was political payback for coming after that?
I think starting with that, that put me, you know, that put a bullseye on me. And then I was handed the assignment of defending the party on the robocall matter. You know, again, I didn't pick that. That was part of the job. It came with the territory. And I think, you know, that just firmly,
But you could have said, no, I don't want to do this.
I suppose. I probably would have had to step down from my position.
And maybe in retrospect you wish you had, knowing where you are today.
It beats being put in shackles, right?
Yeah. You spent 17 days, I think, or 14 days, 17 of the 30 days?
I spent 2/3, so I think it was almost 20.
Okay. So what do you want to happen?
I think Parliament needs to look at this. I mean, I've made the case today that Elections Canada didn't just once, but a number of times violated my charter rights. They can look at that or not. But I think what they can, and I'll put a pile of evidence before committee, more than what I placed before them today, that just underscores the activities of Elections Canada in my case, how they approached it, what they did, how they did it, how they turned every tool and strength. And I've got to tell you, when you go to court against the federal government, as I did, an organization that has unlimited financing and funding, that is not an equal fight. It's not a fair fight.
But you're still before a judge, and the judge at the end of the day, if I recall correctly, I think said that you had lied, that you had, you know, the judge was no friend of yours, obviously, and when the conviction was handed down. So yeah, you were up against the machine of the federal government, but the judge made the decision. Sure,
and if the judge would have had the information and the evidence that Elections Canada suppressed and never provided to me, which was serious evidence, I believe it was evidence that would have completely turned the outcome of the case. And underpinned not just what I was saying, but underpinned the fact that this was a pattern of behavior, that I think the outcome would have been dramatically different. And that's a violation of my charter rights. And I think that the MPs need to look at that. And
in which form? What are you suggesting?
Well, I provided
parliamentary committee, or?
Yeah, I think it should go to committee, and I think ideally the committee should look at everything that's before them. Bring everyone in, me, snc-lavalin, have them provide evidence as to exactly what they did, how it was approached. I think we need to see, you know, all the evidence related to not just, and as I said, it goes beyond snc-lavalin and myself. There's a number of these cases.
But is it, just to be clear, we only have about 30 seconds left. To
Sure.
be clear, do you want an investigation of the actions in particular of the Commissioner of Elections Canada and elections and how they approach these prosecutions?
Yeah.
Or do you want a tighter examination of who gets a compliance deal and who offer and who doesn't?
Yeah, I think we should probably define it, Peter. I don't think we should have a system of selective prosecution. It has to be equal justice for all. We need an egalitarian system of enforcement of the laws that govern our democracy. And without that, and I can assure you, based on, we have a prima facie example that does not exist in Canada today. We need to address it.
All right, Dean Del Mastro, thanks for coming to speak with me. Appreciate it.
Thanks, Peter.